Drivers in Wisconsin, did you know that an officer doesn't need to prove you're drunk to pull you over for a DUI? Let me explain the legal loophole you probably didn't know about. Here's something a lot of people misunderstand. In Wisconsin, an officer only needs reasonable suspicion to pull you over, not hard evidence. Let me paint a picture for you. You're driving home after dinner. You're perfectly sober, but you slightly drift over the center line because you're distracted by your GPS. That tiny mistake? It's enough for an officer to suspect you might be impaired and pull you over. Here's the kicker. If you've had any alcohol earlier in the night, even if it's just one beer with dinner, the officer might use other observations, like bloodshot eyes or the smell of alcohol, to escalate the situation. At this point, you could be subjected to a field sobriety test, a breathalyzer, or even an arrest. The key takeaway here is that reasonable suspicion is a very low standard. It doesn't mean you're guilty, but it's all an officer needs to stop you. This surprises a lot of people who think they're safe as long as they're under the legal limit. If this has ever happened to you or someone you care about, it's crucial to know your rights and what steps to take next. Reach out to me and we'll sit down and go over your situation. I'll help you understand your options and figure out the best way forward. If this video helped you out, give it a like and subscribe for more clear, no fluff legal tips. Got a legal question you want answered in a future video? Drop it in the comments. I actually read them. And if you're curious about more legal topics, check out the other videos on this channel. There's a lot here that could save you time, stress, and maybe even your case. Here at Weston Dunn, your business is our mission. Thanks for watching.